beat his ass for the police come. Bring him up. He's so hard.
He's a trial predator, you fucking idiot! I'm not! Hey everybody, you guys aware that this guy's a trial predator? Yep. Really? Oh, what are you going to do? Get over it.
Get in the house.
You guys saw him hit me with the bat?
Yeah. Well, you should have saw it.
That's it. Let it all out. Let it all out, Cyraxx.
I want to know why you did this to me.
Because you're a child predator. When you scream for help.
All the time I scream for help.
Sure, yeah.
I'm sorry that this happened.
This is a trial one for when they arrest you for being a pedophile. There he goes, everybody. There goes Cyraxx. Bye, Cyraxx. Bye, child predator. Bye.
As the injuries were minor, the APD may not have felt they had enough evidence to charge Chance with assault with a deadly weapon. The DEA now has the videos. On July 3rd, Chance has his arraignment. At this time, the charges will be read to him. The DEA can upgrade the charges based on new evidence, i.e. the new videos, at any time. Chance will have three options to plead: guilty, no contest; not guilty by reason of insanity, or he can stand mute. If Chance pleads guilty, then the judge will set a date for sentencing hearing. This is going to be anywhere from a few weeks to a few months down the road. Can the charges be updated, or should they be? So far we've seen use of deadly weapons. Chance is seen on the video and by witnesses brandishing and using a metal baseball bat. A baseball bat is a deadly weapon in Ohio. Ohio 2923.11-2923.24. Now, according to the revised Ohio Code, a deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon, or possessed, carried, or used as a weapon, which means a baseball bat is a deadly weapon. Did anyone else notice Chance is kind of ringed up? More than the usual amount? Multiple rings are known as a poor man's brass knuckle. Brass knuckles are also deadly weapons. Now, brass knuckles can be brass, plastic, or even wood. Brass knuckles are legal in Ohio, but Ohio requires a concealed carry permit. I kind of doubt that applies to rings, but when not used in defense, they are considered a deadly weapon. While most are going to just dismiss the idea that Chance is strong enough or capable of hurting somebody, the use of deadly weapons shows that he has intent to do so. We've all heard more than one video of how tough he is, and when in my day we used to just knuckle down and do it and get a few lumps and go on. But in every case he does seem to use some kind of weapon or device, doesn't he? Normally Chance is going to wear 1 to 3 rings. That's what plenty of videos that we've seen support this. However, in the assault video it appears to show 2 rows of rings on the left hand, or heavier than normal rings. Now that's a poor man's knuckle duster. It's going to be up to the judge to consider if the rings represented a danger to anyone, and that's if anyone even notices this. The one bat hit was described by AOM afterwards like getting hit with a teddy bear. However, the dangerous thing is that even Chance is capable of swinging fast enough that had he hit AOM in the head, he could have caused serious injury or death. Chance was flailing around with the bat enough that quite possibly an accidental head hit could have occurred. And rings, when used this way as brass knuckles, are quite capable of causing injury or death. That's what defines them as a dangerous weapon. Ohio is a stand your ground state. Chance claimed to police he was just defending his property from multiple people. Remember, Sally reported 8 to 11 people on the front porch going after him. He called them and reported 8 people on the front yard. Video shows only 1. Videos clearly show AOM was at all times on public property. Chance, however, came out to the street with the bat. The videos even show AOM stepping back in reaction to this. AOM was unarmed. No one else is shown anywhere near. Had AOM chased Chance or attacked, then stand your ground might be valid. But don't forget, Chance went after Music Biz Marty a block away and charged him with closed and raised fists. Chance also has a history of domestic violence, including one charge against Sally. I went out to defend my family from the crowd. Stand your ground. What danger? If there was a clear danger to a person on 339 Lloyd, then stand your ground could be applied. AOM is alone on public property holding a cardboard protest sign. What was he going to do to Chance? Give him a paper cut? Most importantly, Chance was safely inside his home. There were weapons inside the home as declared by Sally to police. All he had to do was stay inside and call the cops. So to sum up, an assault occurred. A deadly weapon was used during that assault. And the fact that no one was injured or seriously injured is just luck. At the arraignment. This is usually a simple, very fast court appearance. The judge will recognize Chance as the defendant. He will read him the charges, and ask him how he pleads. The judge is only going to want to hear one of those and nothing else. No arguments, motions heard, just a plea. The judge is not going to want any details from Chance on how the trolls made him do it. That actually tends to rather annoy the arraignment court judges. He just wants a plea so he can set a date for the next stage, if any. If he pleads guilty, that means no trial, no appeal, and just it goes on to a sentencing hearing. If he pleads not guilty, the judge will ask Chance if he wants a lawyer, a trial by jury or judge, and will set a date. Then he'll set any release conditions for Chance. The judge will normally set release conditions that may include things like no internet use, a bond amount change, a monitoring device like a GPS tracker, or a psych exam. If he pleads not guilty by reason of mental impairment or ability, aka the insanity plea, he definitely will get assessed by either a clinical psychologist or a criminal psychiatrist, or even a criminal forensic psychiatrist. Based on the examinations which occur over days, the psychiatrist will report either Chance had not known what he was doing, or was not in control of the time this occurred, or that he knew exactly what he was doing. However, this defense is a long stretch, as the video clearly shows him quite aware of his surroundings, what's going on, and that he was capable of stopping. The judge, after getting the report, could, if he believes it, assign Chance to a group home, to a psych ward or care facility, or proceed with it as a criminal matter. Now, this is just a very hard defense to make work. Standing mute. Standing mute is where a defendant does not plead. This results in the judge entering a not guilty plea by default and setting a trial date. That's what will happen on Tuesday. The judge will accept a guilty plea or set a court date. If he pleads guilty, depending on the court, the judge could pronounce sentence or set a sentencing hearing court date. So what if Chance pleads guilty? You cannot afford a lawyer, one may be appointed for you, or you have the right to represent yourself. The term for representing yourself in court is called pro se or pro per. These are Latin terms. Pro se means for oneself, on behalf of themselves. Pro per, or in propria persona, means in their own person. This is generally not a good idea even if you are a lawyer, aka having a fool for a client. It would be a very, very entertaining, but I just can't see that happening at all. At this point, the judge is going to decide if he'll be held until trial, i.e. his $2,500 bail is going to be revoked, or if he'll allow the bond to continue, or if he needs to make any modifications like increasing it, decreasing it, whatever. I have no doubt he would be right back on the internet within hours if he was restricted from the internet, and that could lead him right back into having his bail revoked if it pisses off the judge. Chance would then sit in jail until the next court date. He might also face contempt charges. No contest or nolo contendere. This is where you claim you didn't commit the crime, but you're unable to refute the charges. In other words, you are pleading not guilty, but you need to wait till you find the evidence or an alibi to dispute it. You might plead this if you're innocent, but you need to acquire evidence or verify an alibi. Chance would have to find a video showing 8 to 11 people on his front porch, as an example. The sentence. If Chance pleads guilty to the simple assault charge, he faces up to 6 months in jail, a fine up to $1,000, and up to 5 years probation. The video evidence along with the baseball bat supports other more serious charges such as aggravated assault and felonious assault. Aggravated assault is a class 3 or 4 felony. It's defined as knowingly causing serious physical harm, or while under the influence of sudden passion or in a sudden fit of rage, knowingly causing serious physical harm to another, or causing physical harm to another by means of a deadly weapon. This one is actually the charge I would have thought that is likely instead of the simple assault. Perhaps with the new videos and such they will upgrade it. If the charges are upgraded, expect it. If they do not count the previous DV charge, then it is a mandatory sentence of 6 to 18 months in prison. Remember in 2012, Chance assaulted Sally and was arrested and pled guilty? That may come back to haunt him. If that was also a simple assault, which I believe it was, then the mandatory sentence is increased to 12 months and up to 60 months. Mandatory. If the charge is upgraded to assault with a deadly weapon, causing or attempting to cause harm with a deadly weapon, and again, baseball bat is considered a deadly weapon in Ohio, the mandatory sentence is 2 to 8 years in prison. Chance's sentence. When sentencing someone, the judge is going to look at a set of sentencing guidelines. This guide makes the judge go over the case with an eye to the facts and circumstances. Things that make the offense more serious, such as causing serious injury or psychiatric harm to the person. Things that make it less serious are like offender's conduct, less serious. Victim induced or facilitated the offense. Offender acted under strong provocation. Now, those two could be argued. Offender's recidivism more likely. The offender has a history of criminal convictions, which he does. The offender has not responded favorably to sanctions previously imposed. Probably not. And the offender shows no generous remorse, which he doesn't. Hours after being bailed out, he was right back at it, not taking responsibility for anything. Convictions or juvenile delinquency adjudications. Convictions or juvenile delinquency adjudications. So this should now give you a good idea of what will happen in court on July 3rd. If the DA considers the video and witness evidence, and especially adds in the evidence from the internet videos, then the charge could easily be updated to something far more serious than simple assault. However, if the DA does nothing, doesn't include that, Chance would face up to 6 months in jail, up to $1,000 fine, and up to 5 years in probation. My guess on this? I didn't research the judge, so I don't know what her history of sentencing is like. But if the external videos are used, then he will get some jail. If the videos are not considered, then it's likely he'll just get a fine and probation only. But we'll find out.